Hello, and welcome to this MBL webinar on IP protection for functional foods and nutraceuticals. Thank you very much for joining. I am Chris Dennison, a UK and European patent attorney and representative for the Unified Patent Court of the European Union. I am a partner in the Life Sciences Practice Group of Newburn Ellis LLP, a UK and German firm of patent and trademark attorneys. It's my great pleasure to have this opportunity to talk to you about this topic, which I personally find very interesting and challenging. This slide presents a brief overview of what I will cover in this webinar. I'll start with a brief introduction of why I have come to be talking about this subject. I'll continue with a relatively basic explanation of European Patent Office practice for foods, and in particular for so-called medical use inventions, which can, in principle, be applied to the health effects of foods. I'll then explain why food labelling legislation in Europe conflicts with this practice and leads to the potential for easily obtainable patent claims that may not be enforceable in practice. To conclude the main part of the webinar, I will discuss various strategies for avoiding potential unenforceability that arises from this conflict. And finally, I'll briefly mention an additional, but seemingly rather little used form of intellectual property protection for health claims made in connection with food products. In reviewing my slides ahead of the presentation, I realized that it would have been more accurate to refer here to data exclusivity rather than to marketing exclusivity, so I apologize for that. I should, of course, add the usual disclaimer that the contents of this webinar are a simplified explanation of European Patent Office practice in this area and do not constitute legal advice.